Good afternoon, everyone. Thank you for joining today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Good afternoon, everyone. Thank you for joining us for today's online talk, which is entitled Money Laundering Offences, Understanding Risk and Compliance under AMLA 2001. My name is Noelle Aoyong. I'm an associate with Ma Wing Kwai & Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Ma Wing Kwai & Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma Wing Kwai. Our able team today comprises 32 lawyers and a support team of 26. Datuk Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 movement control order, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In any event you require specific legal advice to your matter, please contact us for a complimentary legal consultation, details of which will be given at the end of the talk. We have one speaker for today, who is Agalia J. Munasamy, and after the talk, we will conclude with a Q&A session. So allow me to introduce Agalia. Agalia is a senior associate in our criminal, civil litigation, family, and matrimonial teams. She graduated with a Bachelor of Laws from Aberystwyth University and was admitted to the Malaysian Bar in 2014. She's involved in advising on criminal defense strategies, anti-money laundering, corruption charges, customs and smuggling offences, and immigration offences. Agalia's area of practice include criminal law, general litigation, debt recovery, and constitutional matters. So today's talk points are understanding money laundering offences and penalties, risk and compliance with AMLA 2001 and other laws, and lastly, client due diligence and suspicious transaction report. If you have any questions, please don't forget to type it up in the Q&A chat box. I will now hand over the session to Agalia.
Hi, good evening, everyone. My name is Agalia, and I will be your speaker today. And our topic today is understanding money laundering and the issues that arises with money laundering. Thank you, Noelle, for your introduction. That was very clear and concise. Without much ado, let's proceed to our talk today, which is to understand what money laundering is. So money laundering is a process of converting cash, funds, or properties derived from criminal activities to give it a legitimate appearance. It is basically a process to clean dirty money in order to disguise its criminal origin. So how do criminals launder money, you may ask? There are 3 stages, and these 3 stages was actually defined by Bank Negara Malaysia somewhere in 2001. So what it means actually, there are 3 stages in money laundering process. The first of it is placement, the second would be layering, and the third is finally integration. So in placement, what do we mean is that someone moves the unlawful proceeds from its source and place it in a reporting institution. So illicit funds are here. What that means in placement is that illicit funds are separated from their illegal source. This typically happens when illegal funds are placed into a reporting institution. Examples of this may include depositing cash into bank accounts using ATM teller machines, or it also could be currency exchange via purchasing of foreign money using proceeds of unlawful activities. And the third example that I could give you is purchase of gambling chips. Okay, and then what happens after all this process has been done is the process of layering. Layering is basically disguising the trail or layering the illegal nature of the proceeds that you have gotten. Layering is basically creating multiple layers of transactions to distance or disguise the illegal funds from their illegal sources. Okay, this is to obscure or to make it difficult to trace the origin of the illegal funds. This may involve multiple transfers between accounts, hiding funds in shell companies or trusts, or transferring funds into multiple assets. So examples of layering would be multiple funds transferred to onshore and offshore bank accounts. And finally, we have the integration part, which is making the fund available for enjoyment and makes it appear legal. In integration, which is the final stage, where the laundered proceeds are successfully integrated into the economy, appearing as legitimate funds. This may include purchases of properties of high value, goods, and investment into business venture. So certain examples of how money is laundered that is finally integrated into the economy would be purchasing and investing in property, purchasing luxury goods, perhaps a branded bag, iPads, and this may also include jewelry. Okay, and then engaging in legal business via capital investments or injections. So once this stage has reached, the criminal has completely legitimate reasons for having the funds and he or she does not need to hide it any longer. Now let's move on to the next slide. The Anti-Money Laundering, Anti-Terrorism Financing and Proceeds of Unlawful Activities Act, which I will hereinafter refer to as AMLA, is designed to be in conformity with international agreements and treaties on money laundering. The FATF, which is basically the Financial Action Task Force based in France, they have given their own recommendations, which is to ensure a coordinated global response to prevent organized crime, corruption, and terrorism. They help authorities go after the money of criminals dealing in illegal drugs, human trafficking, and other crimes. The Financial Action Task Force also works to stop funding for weapons of mass destruction. So money laundering legislation around the world, if you were to look at different countries, basically that would be money laundering acts in Malaysia, in Singapore, in India, in US, they would all generally be pari materia. So what this means is they actually sound similar to each other, as they all have to satisfy the same international obligations under the recommendations of the Financial Action Task Force. It is also worth mentioning that one of the peculiarities of AMLA is that it's extraterritorial and it is retrospective. This is mentioned in Section 2 of AMLA, that this act shall apply to any serious offense, foreign serious offense, or unlawful activities, whether committed before or after the commencement of this date. And that makes it retrospective, and that this act shall apply to any property, whether it is situated in Malaysia or outside. Technically, that makes it extraterritorial. So moving on to understanding the act of money laundering. So the act of money laundering is defined in Section 4 of AMLA as any person who engages directly or indirectly in a transaction that involves proceeds of unlawful activities or instrumentalities of an offense. Or it could also be any person who acquires, receives, possesses, disguises, transfers, converts, exchanges, carries, disposes of, or use proceeds of an unlawful activity or instrumentalities of an offense. It could also be any person who removes from or brings into Malaysia proceeds of unlawful activity or instrumentalities of an offense. Or it could be any person who conceals, disguises, or impedes the establishment of the true nature, origin, location, movement, disposition, title of, rights with respect to, or ownership of proceeds of an unlawful activity or instrumentalities of an offense. The knowledge part of money laundering, which is provided for in subsection 2 of section 4 AMLA for the purpose of the earlier actus reus, which was discussed earlier, in determining the knowledge of a person who is charged with money laundering offences, it can be derived from objective factual circumstances, and that is the person knows, has reason to believe, or has reasonable suspicion that the property is the proceeds of an unlawful activity or instrumentalities of an offense, or the person without reasonable excuse fails to take reasonable steps to ascertain whether or not the property is proceeds of an unlawful activity or instrumentalities of an offense. So now you would have heard me speak a lot about unlawful activities, proceeds of unlawful activities, and serious offense. So what does this mean? Basically, Section 3 of AMLA defines the important terminologies and words that will be used over and over again in the whole of the structure of AMLA. So let me begin by describing what is unlawful activity. Unlawful activity, as defined in Section 3 of AMLA, means any activity which constitutes any serious offense or any foreign serious offense, or any activity which is of such nature or occurs in such circumstance that it results or it leads to the commission of a serious offense, regardless of whether such activity wholly or partly takes place in Malaysia. So now, what is proceeds of unlawful activity? Proceeds of unlawful activity, again as defined in Section 3, means any property or any economic advantage or economic gain from such property within or outside of Malaysia. The next one would be, what is a serious offense? You have heard me speak about serious offense again and again, but no one knows what is a serious offense. So serious offense means any of the offenses specified in the second schedule of AMLA, an attempt to commit those offenses in the second schedule, or an abatement of those offenses. Let's move on to the penalties and offenses under AMLA. Section 4, subsection 1 of AMLA prescribes the penalty for money laundering. Upon the finding of guilt and conviction, Section 4 provides that any person who is found guilty can be sentenced to imprisonment for a term of not exceeding 15 years, or fine, and shall be fined for not less than 5 times the sum or value of the proceeds of unlawful activity, or 5 million ringgit, whichever is higher. So what this means is, just imagine someone has actually laundered maybe 2 million ringgit. So 5 times the sum of that value would be 10 million. But this also provides for 5 million, which means whichever is higher will be considered. That means it will be the 5 times the value and not 5 million ringgit. Did you know that imprisonment and fine is not the only way to recover unlawful proceeds from the launderer? The Malaysian Anti-Corruption Commission, the MACC, is empowered to enforce recovery of stolen assets via AMLA. Of late, there is much misunderstanding over the use of compounds as one of the strategies to recover assets using the act itself. In a layperson's mind, a person who has been charged and found guilty of money laundering may be punished by jail sentence, a large sum of fine, in addition to recovering all of the stolen assets. In reality, however, it is much more complicated than that. Recovery of laundered money has become increasingly difficult and more challenging due to the changing modus operandi of criminals by operating in syndicates and laundering their ill-gotten gains through legally registered company with proxies and nominees as fronts to hide their wealth. So this makes it extremely difficult to go after a person for the direct act of money laundering. Because of this, the authorities are actually empowered by the law to initiate criminal prosecution, but not only limited to criminal prosecution, but also civil forfeiture, compound fines, return of assets to bona fide owners, and asset recovery from absconded persons. This is demonstrated by Section 56, subsection 1 of AMLA, which provides that subject to Section 61, which, as I mentioned earlier, is for bona fide owners to claim their goods. Okay, so subject to Section 61, where in respect of any property seized under this Act, and there is no prosecution or conviction for an offence under subsection 4, subsection 1, or a terrorism financing offence, the public prosecutor may apply to the judge of the High Court for an order of forfeiture of that property if he is satisfied that such property is a subject matter or evidence relating to the commission of an offence, or if that subject matter is proceeds of an unlawful activity or instrumentalities of the offence. So what is property, you may ask? We go back to the defining section 3 of AMLA that states any assets as being assets of every kind, whether corporeal or incorporeal, movable or immovable, tangible or intangible, however acquired. So this basically makes the word property as a very wide, is given a very wide definition, and that means there are a lot of things that can be recovered from a money launderer in that sense. So I will move on to section 86 of AMLA, which is basically a general penalty, even if you're not charged for any other offense or any other money laundering act. So the general penalty provides that any person who contravenes any provision of this act or regulation made under it commits an offence and shall, on conviction, if no penalty is expressly provided, be liable to a fine not exceeding 1 million ringgit. So this is the very general provision that anyone can be charged, especially if there is reasons to believe that you have committed or contravened any act, any section of this act. Okay. Criminalizes money laundering and lifted bank secrecy provisions for criminal investigations involving more than 180 predicate offences in the second schedule. The second schedule of AMLA includes money laundering as the first predicate offence and is followed by other illegal activities related to money laundering, such as bribery and corruption, human trafficking, arms stealing, drug trafficking, unlicensed banking and financing, illegal betting, kidnapping, unlicensed foreign companies, illegal smuggling, unlicensed money changing, and other relevant penal code offences, and etc. There are some examples that I would like to give here as for the other act that is listed as a serious offence pursuant to the second schedule of AMLA. And one of it is actually anti-trafficking in persons and anti-smuggling of migrants. So what are some offences that may constitute the second predicate offence under this act, which I'm going to name ATIPSOM, would be offence of profiting from exploitation of a trafficked person. That is a sample offence that could be a second predicate offence. And if you have been charged and convicted under that offence, basically that could mean that you can also be liable to be charged under section 4, subsection 1 of AMLA. And then the other example that I could give you is under the Capital Markets and Services Act 2007. You can be charged with false trading and market rigging transactions, stock market manipulations, false or misleading statements. So even as I've mentioned earlier, if you have been charged and convicted for these charges, then naturally that would mean you could still be subjected to an offence under section 4, subsection 1. Let's move on to the other acts that are listed in the second schedule. This would include Child Act 2001. Some of examples of offences here would be offences relating to selling, procuring, detention, or any attempts of child prostitution. So that would be a second predicate offense. And then there also examples under Companies Act would be loan to directors, prohibition of loans to persons connected with directors, fraudulently inducing persons to invest money in your business. So these are examples of serious offenses under the Companies Act. And then let's move on to the Controlled Supplies Acts, whereby if you were caught or if you're charged with unlawful possession of controlled articles, that would mean you could still be charged under Section 4 of AMLA. And then Customs Act would generally be making incorrect declarations and falsifying documents, and also includes smuggling offenses. Under Financial Services Act, a serious offense under that would be non-compliance with the directions issued by the bank. So this is definitely a very serious offense under the Financial Services Act. And there's also a GST Act, which means if you are to make incorrect return, evasion of tax or fraud under GST, then you would be liable and subject to investigations under Section 4 of AMLA. And there's also Kutu Funds and the Malaysian Anti-Corruption Commission Act. So offenses of accepting gratification, corruptly procuring withdrawal of tender, bribery of an officer of a public body, and offense of using office for position or position for gratification could all be considered serious offenses under the AMLA. Okay, so to avoid all these penalties and serious offenses, it is highly recommended that businesses and organizations conduct client due diligence. This client due diligence is actually provided for under AMLA itself, pursuant to Section 16 of AMLA. Every reporting institution is required to do client due diligence. But as lawyers, I think we would really generally recommend every organization to conduct their own due diligence, even if it's not provided for in the Act or in any act that regulates your business. So businesses and individuals face heightened scrutiny concerning their financial transactions in today's globalized financial landscape. Preventing money laundering charges is paramount, and a proactive approach through robust compliance and diligent prevention strategies is essential. So this is why we said even if the act that governs your business does not require you to conduct client due diligence, it is still recommended that you do to avoid your company being a conduit for money laundering. Section 16 AMLA provides that every reporting institution conduct appropriate CDD for every transaction. Who is a reporting institution? The first schedule of AMLA has a list of reporting institutions such as licensed bank, an approved financial advisor in relation to life business, an approved insurance broker in relation to life business, approved money broker, fund management, common gaming house, and these are like operators of games such as roulette, black 21, poker, and etc. This Section 16 of AMLA is also applicable to accountants, solicitors and advocates, notary public, pawnbrokers, and real estate agents, just to name a few. Okay, the Central Bank of Malaysia, BNM, outlines the guiding principles to all reporting institutions in their policy document. So this policy document is called Anti-Money Laundering, Countering Financing of Terrorism, and Targeted Financial Sanctions for designated non-financial businesses and professions and non-bank financial institutions. So client due diligence is a process of identifying and verifying the identity of your customer. So in other words, client due diligence is also otherwise known as KYC or Know Your Customer procedures. Reporting institutions basically must be satisfied that the customers are who they say they are. This includes knowing the identity of your customer, the identity of the beneficial owner, i.e. the people behind the transaction, the identity of persons conducting the transaction if the transaction is done on behalf of someone else, or the legal person or the person you are dealing with is a representative appointed by a legal person, and also to know the purpose or why the transaction is being undertaken. So customer due diligence is recommended to be carried out at following stages. The first stage is definitely in your onboarding stages for new customers. Secondly would be from on a time-to-time basis throughout the business relationship after the customers have been onboarded. This can apply for existing customers and at the point of transaction. This is for one-off transactions, for occasional transactions, and for transactions exceeding certain threshold imposed or where there is suspicion of money laundering. So when I say there's a certain threshold imposed, just for your information, for the current threshold that is recommended by the Bank Negara Malaysia would be 25,000. So any transaction that would involve moving large sums of monies more than 25,000 would actually be a point where you should conduct CDD. So why you may think client due diligence is important? So client due diligence, as I mentioned earlier, is important to confirm the identity of your customers. It is to enable risk profiling of your customers. It's also to prevent abuse by criminals and to assist law enforcement agencies. And when we speak about identity of customers, you have to be certain who the organization is dealing with and to ensure that the company is not dealing with listed entities or persons under the targeted financial sanctions regime. So this targeted financial sanctions regime is something that is done by Bank Negara Malaysia and it's available on their website. You can go and check any organizations that actually been sanctioned by Bank Negara Malaysia for this purpose. And when you speak about risk profiling, what client due diligence does, it is ensures the organization has the required information to profile customers and assess the money laundering or the terrorism financing risk on the customer who may pose a risk to your business or organization. It is also to prevent abuse by criminals, and that means sometimes criminals use proxies or appoint another person to conduct business on their behalf or transactions on their behalf. This helps shield their own identity, so you're never going to find out who is the real person who you are dealing with behind the identity of this proxy that you know. This helps shield their own identity, and without proper customer due diligence, the organization may unwittingly be helping a criminal launder money or finance terrorism. In a way to assist law enforcement agencies, what client due diligence can do is that the information that you've gotten from your due diligence may be vital for law enforcement agencies in undertaking an investigation. So especially on persons of interest and anyone related to them. What can I do if my client refuses to comply with my CDD requirements? So in principle, I would suggest that organizations and businesses terminate their business relation with their existing customer and should not commence the onboarding of a potential customer if they are unable to comply with the client due diligence requirement. Therefore, if a customer refuses to provide his ID, this can constitute as failure to complete customer due diligence, and the organization shall not continue dealing with the customer. However, in the case where there is a suspicion of money laundering or terrorism financing activities, and the organization believes that by completing the CDD, it would tip off the customer, then they may actually proceed with the transaction without completing the customer due diligence, but must immediately lodge a suspicious transaction report within the next working day. So what is a suspicious transaction report? A suspicious transaction report, or commonly known as STR, is the obligation of reporting STR, which is only imposed on reporting institutions. However, a non-reporting institution, including public, who have any information pertaining to any suspected activities relating to money laundering or terrorism financing done by someone they know, can personally contact BNM and let them know what are the informations that you have gathered. So although the imposition is just on reporting institutions, it is generally advised for the public to report any acts of money laundering that they have come to knowledge of. And the STR is a report that the reporting institution submits to the Financial Intelligence and Enforcement Department. So this FIED is a functioning department under the Bank Negara Malaysia and is overseen by Bank Negara Malaysia to identify suspicious reports or suspicious transactions. And the report is usually done whenever the reporting institution suspects or has reasonable grounds to suspect that the transaction, including any attempted transactions or proposed transactions, regardless of the amount, appears unusual, has no economic purpose, appears illegal, involves proceeds from an unlawful activities or instrumentalities of an offense, or indicates that the customer is involved in money laundering or terrorism financing. Ultimately, the decision to submit a suspicious transaction report still remains with the compliance officer. A compliance officer under the organization is one who is appointed pursuant to Section 19 of AMLA. This compliance officer basically reports to BNM and is a point of contact for anything related to AMLA compliance within the organization. What are the importance of STR? Suspicious transaction reports provides the financial intelligence unit and subsequently law enforcement agencies with valuable information of potential criminal activities. There are certain red flags that may trigger these kind of transactions. So it's not always something that is automatically when it's worth 25,000, then it should trigger the suspicion. That's not the case. Basically, there must be some red flags that should lead to this suspicion that you may have. So every reporting institution must establish their own red flags to help them and their employees identify situations which may require STR to be submitted. These red flags, as I mentioned, vary depending on the sector and specific businesses the reporting institution is in. So the kind of red flags that if you were to look generally that will help in your business or in your organization, these red flags can be identified in the BNM's policy document, which I mentioned earlier. And some of these red flags are really industry specific. If you do not have any idea of what a red flag might be, then I would suggest that you look up the policy document on BNM's website, and they have very intricate red flags that anyone can refer to. So when you are submitting a suspicious transaction report, here are some of the do's and don'ts of submitting the reports. So please do ensure that STRs are submitted within the next working day from the date of the compliance officer establishes the suspicion. As I mentioned earlier, when someone refuses to complete your client due diligence procedure, but you have suspicion that if they were to comply, then it might be some sort of tipping off for them, you can avoid the CDD, but please comply with submitting the suspicious transaction report by the next working day. And then you please do establish reporting mechanisms for submission of STR. So this is something that's got to be undertaken by the organization together with the compliance officer to ensure that there's clear guidelines and reporting mechanisms within the organization for submissions of STR. Okay, and then you can establish policies on the duration for compliance officer to review internal STRs. So STRs are usually submitted to the compliance officer by any employee. So just let me give you an example. If you're to work in a bank and you're the person who is at the counter, so what you can do is to report a STR to your compliance officer, who is then going to review that report and to decide whether it is fit for being reported to BNM. And please do ensure that the STR is treated with utmost confidentiality. So this brings me to the next point of the don't, which is to disclose the submission of STRs to anyone else except under certain circumstances. Please do not go and tell your co-worker or anyone else that you're close to in the office, that you feel like there's some kind of suspicion, you're going to make a suspicious transaction report on this transaction to your compliance officer. Please don't do that. Please keep it private and confidential at all times. Even worse than telling your co-workers, don't tell that person itself. So please don't tip off the person. So there's a risk of you, when you tell other people that you're going to submit this report, there's a risk of that person being tipped off and they may call off the transaction altogether. Okay, so please don't behave suspiciously and do treat them as your normal client so that they don't suspect something is going on behind the scenes. So this brings us to the end of my presentation. We will move on to our Q&A session. Do we have any questions?
Thank you, Agalia, for your insights in money laundering offences. All right, everyone will now be having the Q&A session. So we will now take questions from the participants which have been posted in the Q&A chat box. Okay, we will now start with the first question from Ms. Catherine Lee. The first question would be, so significant sales proceeds of property deposited into bank accounts would immediately trigger STRs. Banks would immediately need to report such receipts as STRs first or verify such transactions with their customers first, then file STRs with Bank Negara if transactions are really suspicious.
Okay, so to answer Catherine's question, basically, as I mentioned, every reporting institution and a bank is definitely a reporting institution. So what happens is they would definitely inquire the purpose for which the transaction is being made. And if someone were to buy a house cash, then definitely that would be a suspicious report. But what can happen after the report is made is the bank would proceed to verify with their client on the background of how you've gotten the money or what was done for you to procure this large amount of cash. So it would not necessarily immediately trigger the STR, but the banks definitely have to conduct their due diligence at this point. As I've mentioned, even at onboarding stages or throughout their transactional relationship, the banks can always carry on with their customer due diligence at all times. So Catherine, to answer your question, it does not necessarily trigger an STR, but there are several steps that must be taken before the compliance officer concludes that this is suspicious.
Thank you, Agalia. Now we'll move on to the second question. Is it mandatory to do CDD or KYC on client who is a sole proprietor and partnership?
My very simple answer is yes. You have to do customer due diligence on every single customer that you are having to have, that you're going to have a transactional relationship with. The only time I would say that this can be avoided, as I mentioned, the customer due diligence is an imposition of AMLA on reporting institutions. So if you are a reporting institution, whether it's a sole prop or a partnership, you must conduct your customer due diligence. The only time this becomes not mandatory is when you are not a reporting institution. So basically, like we are a law firm and we have to do our customer due diligence, even if it's a sole proprietor, even if our clients come for a single individual matters. So we know we are dealing with individuals directly, but it is our duty to conduct client due diligence in accordance to AMLA requirements.
Right now, the third question, should the KYC form be completed by the RI or let the client to complete it and return to the RI?
Okay, so what can happen here is if you were to allow your client to complete the KYC, there are instances where even those informations can be misleading. I would suggest that the RI collect the necessary documentation required to complete the KYC. Otherwise, if you were to allow your clients to complete their own KYC, you will have to collect supplementary supporting documents to verify the information that they've provided to you.
Next question from Dilaga. Can we complete the transaction despite CDD findings show that the customer is high risk and then raise to the compliance officer?
Okay, once your customer is already high risk, that means you have already done your CDD. So what you can do when your customer is high risk is there is something called enhanced CDD. So this is something you can undertake. The enhanced CDD is also provided for in Bank Negara Malaysia's policy document, where it shows you the kind of documents, the kind of information that you're supposed to get from your customer or clients at that time. And despite this, what I would suggest is do not complete the transaction if you know it is high risk. Once you have established the fact that this transaction is high risk, you are supposed to submit the STR immediately. So as I mentioned earlier, I think you would have said, oh, so I cannot complete CDD if I do think it is going to be a tip-off. But if you have already identified that this is a high-risk transaction, then please maintain your CDD requirements and please lodge your STR immediately with Bank Negara Malaysia.
Next question. Is it a requirement to do CDD or KYC on client who is an association registered with R?
Yes, if you are a reporting institution, then regardless of who the person you are dealing with, there is a need to do CDD and KYC. And what happens if you are an association registered with the ROS, right? is that sometimes this is not an updated information. The ROS actually lets it's a company, let the company or a business to update the information whenever they would want. So this is not to say that it's an updated information at all times. So what you have to do is to ensure that at all times, you have the updated records and don't rely on the information provided by other parties.
Next question we have. I work in a corporate company, non-banking. I noticed that very unusual transactions with the vendor for the supply chain. However, the vendor's business nature stated in SSM is completely different as what they supply to us. Those transaction amount is huge. Could it trigger and lead to money laundering too?
Okay, so what can happen? I am dealing exactly with a situation like this at the moment. So we have advised that you have been supplied with information by the vendor, and what happens is you have a duty to follow what's in the SSM. So what happens here is you might be dealing with a company whose SSM is very different than the account that they give. But in this kind of transaction, I would say that yes, if the amounts are huge, it could trigger some sort of investigation. But in all circumstances, you are expected to do your customer due diligence. And if you do have, so what I would say is check and double check and triple check on all of your bank accounts that you've received from your clients. You can check back with them whether this is before you undertake to transfer the monies. You can just send an email to the finance department or anyone to just confirm that this is your account. We will only transfer the money upon your confirmation. These are the kind of things that you can do to avoid raising any kind of suspicion. But what I would say for this question is that there wouldn't be an investigation of money laundering on this company that is transferring the money. I think what your worry is if there would be an investigation on your company itself, and I would say there's not much that you can do at that point. There will not be any investigation of money laundering on your company, especially if you have received information or at least that your paper trail is supported by documents provided by your customers, then it should be fine.
Must an RI adopt AMLA policy?
Yes, of course. So what happens if you are a reporting institution and you do not have AMLA policy and guidelines implemented in your organization is that you are still liable to the general penalty section, which I had mentioned earlier, which is section 86 of AMLA. So you can and you will be liable to a fine of not exceeding 1 million ringgit. So to avoid any kind of general penalties being imposed on you, I would suggest that you adopt all policies relating to AMLA, especially if you are an RI. So this includes having a compliance officer. This includes doing your customer due diligence and so on and so forth.
Another question, RI. Should the RI carry out CDD on the association itself or its members?
So you are basically carrying client due diligence on your clients. If you're an RI, you are required to carry out your client due diligence on your customers. Basically, what it means is, if I'm running a law firm and we are a RI, I am supposed to conduct my due diligence on my clients, not on my employees. So I hope that answers your question.
All right, the next question. This participant says, I'm a company secretarial services firm. During incorporation, the promoters informed me the company's nature of business would be in trading in car spare parts. But after incorporation, the client changed its nature of business to investment holding without informing me of the change. Would that be considered as suspicious when I notice the management accounts indicate a high amount of investments, but the paid-up capital is RM 100? The accounts further show the company owes the directors a lot of money, probably to finance the investment.
Okay, I think this is highly suspicious. As a company secretary, I think you should be informed beforehand of the change in the nature of business by any of your clients. So it is suspicious, but I would recommend you to do your part, which is your client due diligence. And please gather as many information as you can. But there is what you can do, as I mentioned in the slides earlier. If you are not a reporting institution, you can still submit reports to Bank Negara Malaysia as an individual or following their BNM link, which is provided for in their website.
The next question is from Mr. Jo Chia. One of my clients is a government agency. Is CDD required?
No, government agency is exempted from client due diligence. However, do take note that you are supposed to have authorization letter at all times when you're dealing with the government agencies, and that the government agency provides the authorization letter to that employee or to the PIC to deal with your organization.
Moving on to the next question. My client instructed me to prepare documentations for an increase in paid-up capital to a substantial amount. Later on, I noticed that the company has amount owing by directors, but it seems like the additional capital was not utilized for any capital expenditure or for operation expenditure. Is the usage of loans to directors a possible means of layering?
Basically, as I think I've mentioned earlier in my slides, loan to directors is actually a serious offense. So yes, this is highly suspicious. If I could go back to my slides, I think it was under the Companies Act, you are not allowed to provide loans to directors or loans to persons associated with directors. So I think there is something here. You should do your enhanced CDD at this point to ensure that there's no layering or money laundering being taken place here.
All right, we'll be taking one last question. The association is a client of RI. The association has 20 members who are Sdn Bhd and government agencies. So should the RI conduct CDD on the association itself or all those 20 members?
I think this is relating to our earlier question where they asked if the RI should conduct CDD on the association or its members. Okay, Sdn Bhd companies, yes, you will have to carry out your CDD at that point. But government agencies, I think I've mentioned earlier to another attendee that they are exempt from the they're exempt from the CDD, but do make sure that you have their letter of authorization by the government agency to act on their behalf. I think it does not, government agency, does that mean, actually I need a little bit more clarification on this. It could be NGO or a government agency related organization. I'm not exactly sure at this point. But if they are an NGO, yes, you have to do your client due diligence. Unless you are dealing directly with ministries, then you are exempted from conducting your CDD and KYC. So once again, I will repeat myself there. If it is a government-related agency or government-associated agency, then you have to do your CDD. But if it is ministries themselves that you are dealing with, then you're exempted from conducting your CDD.
Thank you, Agalia. All right, everyone, I think that's all we have for today. And before we conclude, I have a few announcements to make. All right. So first, please join us again for our upcoming talks. Our next talk is on the 13th of December. The speakers will be John Chan and Jasmine Wee on the topic of absenteeism and abuse of annual and medical leaves. You can also scan the QR code on the screen to sign up for our online talks. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat box. And thirdly, do follow or like our social media accounts. We are on YouTube, Twitter, Instagram, LinkedIn, and Facebook. And fourthly, if you'd like to speak with our lawyers, we offer a complimentary 30-minute consultation over the phone or over video conference. So please fill in the form on our website, and the link is also posted in the chat box. To our guests, thank you so much for joining us, and we hope you have found today's session informative and useful. Thank you, everybody, and see you at our next talk.
Thank you.